Okay, is everybody ready? Timekeepers ready, teams are ready, judges are ready. Court is in session.
May it please the Court. Good afternoon, Your Excellencies. My name is Liana Young, and I, along with my co-agent, Krista Laser, represent the applicant, the Republic of Esperantia. I will discuss liability for damages to Starflight 1, a vehicle that carried Esperantian citizens, while my co-agent will discuss liability for Station Ferry's landing in Esperantia, as well as Esperantia's prosecution of individuals within its territory. Before I begin, I'd like to note that we've each requested 13 minutes for our arguments, as well as the remaining 4 minutes for rebuttal. Your Excellencies, consistent with the principle of state responsibility, Republica is liable to Esperantia for Starflight 1's damages under 2 alternate theories. First, Republica is absolutely liable under Article 2 of the Liability Convention because, as I will discuss, Starflight 1 was an aircraft in flight. And second, and alternatively, Republica is liable to Esperantia under Article 3 of the Liability Convention because Starflight 1's damages are attributable to Republica's fault. First, to discuss absolute liability. Article 2 of the Liability Convention provides that a launching state is absolutely liable to pay compensation for damage caused by its space object to an aircraft in flight. And pursuant to Article 6 of the Outer Space Treaty, a state is responsible for all national space activities conducted by both governmental as well as non-governmental or private entities. And after looking at the definitions outlined in Article 1 of the Liability Convention, it is clear that the real issue is whether Starflight 1 can constitute an aircraft in flight. So we turn to both a functional and a spatialist approach. Annex 7 of the Chicago Convention adopts a functionalist approach by defining an aircraft as a vehicle that can derive support from the reactions of the air, other than the reactions of the air against the Earth's surface. And applying this definition, Starflight 1 was an aircraft in flight because it was struck while using only its wings for stabilization, support, and flight. Now, the Chicago Convention's definition may be applied in this case because both Republica and Esperantia are parties to the Chicago Convention.
Counsel, does it matter that Starflight 1 was advertised as a spacecraft and that it would take its passengers into space?
Respectfully, Your Excellency, given current technology, hybrid vehicles are possible. And while Starflight 1 may have been considered a spacecraft while using its launch capabilities, it was struck while only using its wings for stabilization, support, and flight. Thus, it should constitute an aircraft in flight. And additionally, under the spatialist approach, Starflight 1 can be considered an aircraft in flight. And this approach defines an aircraft as a vehicle within airspace. Most international literature recognizes a delimitation line converging at around 100 kilometers above mean sea level. And Republica itself...
Can we go back to the operation of the craft itself? Are you saying that something can be both an aircraft, it can be an aircraft sometimes and a spacecraft at other times?
Yes, Your Excellency, and both space experts Marietta Banco and Bruce Hurwitz note that hybrid vehicles are possible given current technology, and in fact, under the Spaceless approach, which Republica itself defines in its Space Activities Act of 2000, a vehicle would be an aircraft while in airspace, and then a spacecraft while approaching outer space. And again, Republica's Space Activity Act adopts the spatialist approach by defining a space object as a vehicle or a payload.
How much weight do you want us to give to the law of Republica?
Well, Your Excellency, given the customary international law of both the functionalist approach and the spatialist approach, Starflight 1 should be considered an aircraft in flight, and as previously noted, most international literature...
Yes, but you brought up the law of Republica, it's a 100-kilometer delimitation. Do you want us to give that weight? I mean...
Absolutely, Your Excellency. However, it is not needed in this circumstance because, again, international experts recognize a delimitation line of 100 kilometers above mean sea level. But Republica's own admission that 100 kilometers is the appropriate delimitation line should be viewed as supplementary in the fact that Republica itself defines outer space at 100 kilometers, should make it bound by that definition.
Excuse me, isn't the purpose of making a definition as to what is operating according to principles of aerodynamics airspace? Isn't that really what it's about when you start making definitions as to what is functioning as an aircraft or as a launch vehicle? Launch vehicles function as habitable airspace, and they also interact with normal aerodynamic principles, even when sitting on the pad. What is the reason for this distinction?
Well, the reason for the distinction between an aircraft and a spacecraft is to determine whether or not a state has engaged in space activities. And in this case, Starflight 1 was an aircraft in flight because it only went up to 93 kilometers and again, was using only its wings for stabilization and flight. However, if this court does find that Starflight 1 was not an aircraft, then it would be a vehicle launched into outer space. And thus, it will constitute a space object under Article 1D of the Liability Convention. And that would bring us to Republica's liability under Article 3 of the Liability Convention. Article 3 provides that if damage is caused to a space object by one launching state, by a space object of another launching state, the latter is liable if the damage is due to its fault. And in 1949, this court in Corfu Channel applied fault liability as it related to state responsibility by finding that a state is at fault and responsible when it fails to act with due care. And as your excellencies are well aware, in that case, this court found Albania liable to the United Kingdom for destroyed sea vessels and deceased passengers because Albania failed to act with due care in maintaining an international waterway.
Why in your argument is the object that was released a space object?
Well, Your Excellency, under Article 1D of the Liability Convention, a space object is defined as a space object or a component part or a launch vehicle or part thereof. And Republica, again, in its Space Activities Act, further defines space object as a payload or any part if it is intended to reach 100 kilometers above mean sea level. And
Which the Republica statute is more precise than the treaties, isn't that correct?
That's right, Your Excellency.
And you're asking us to look to that statute again.
Well, Your Excellency, the Freemake capsule in this case can be defined as a space object merely under the Liability Convention Article 1D because it was a component part of the spacecraft. It went up with station ferry and was a component part thereof. However,
how is it a component part? It didn't have anything to do with the functioning of the spacecraft at all.
well, respectfully, Your Excellency, it was a component part of the spacecraft because it was intended to be a part of Station Ferry's launch and intended to go up into outer space to the Republican space station. And given the purpose behind the Liability Convention, the purpose to ensure that states take responsibility for space activities, this court should broadly construe the term space object and component part, especially given Republica's Space Activity Act, which defines component part as a payload. And
well, I'm not sure it's a component part here. If it was smuggled on board or somehow otherwise, put on board illicitly and was released, contrary to the regulations of the Republica's space agency and all that. So how does that elevate it to a component part here?
Respectfully, Your Excellency, and that brings me to my next point about whether or not Republica was at fault for this action. Republica did authorize Station Ferry to take the Freemake capsules into outer space with the Station Ferry vehicle, and thus it is a component part, and Republica authorized that transportation.
Well, let me ask you, try a different way, Counsel. Is there anything which would be launched into space on a space vehicle that would not, under your definition, be a component part?
Respectfully, Your Excellency, I don't have an example because, again, component part should be read broadly, and if it is a man-made object going, perhaps an individual human being, but this court does not have to decide that fact because the Freemake capsule was clearly a component part. Again, it was man-made. It was intended to be taken up with the Station Ferry vehicle, which is a space object, and thus it should be considered a component part.
Counselor, if we can go to your responsibility argument, I believe that a court in Republica has already found that Republica is not responsible. You have asked us to give weight to 2 items of Republica's law, but are you at the same time asking us to ignore the decision of Republica's courts?
Well, Your Excellency, in that case, Aspirantia as a state did not bring the claim. It was only Star Tours, and the Court of Republica summarily dismissed that claim with only hearing from one expert. And so we would ask this court to reevaluate.
Did Esperantia not have an opportunity to participate?
It is unclear from the facts at hand, Your Excellency. However, both Esperantia and Republica have submitted this claim to this court, and thus there should be no jurisdictional issues at hand. And Republica
Go on.
did act at fault in this case by failing to observe its responsibilities under the Outer Space Treaty Articles 9 and 11. And Article 9 provides that states must undertake international consultation before conducting any activity that may cause potentially harmful interference with the activities of other states. And similarly, Article 11 provides that states must inform the public to the greatest extent possible of the nature, conduct, and location of such activities. These articles recognize the inherent hazardous nature of space activities, which include the dangers of environmental harm and space debris. And this is consistent with Article 1 of the Outer Space Treaty, which provides that outer space is a province of all mankind. And again, Republica breached its duties under the Outer Space Treaty because it did not notify any other nation of the release of cremains. And this is despite the fact that Starflight 1's flight was widely promoted to occur on the same day as the release of cremains. And as Professor Carl Christall notes, reasonable actions may be directly correlated to the foreseeability of harm. And here harm was directly foreseeable. Environmentalists, astronomers, space scientists in Republica and around the world protested this use and pollution of outer space. And yet, Republica did not notify Esperantia nor any other state of its authorization of the release.
Well, counsel, the remains that were protested did not cause this accident. It was something completely, again, as I mentioned earlier, as I understand it, illicit or illegal. It was an illegal act by a private citizen. So I'm not quite sure that I'm following your argument here.
Well, Your Excellency, the incident at case did occur from Mr. Ash taking a private cremain capsule into the Republican space station. But again, Republica authorized Station Ferry to bring up those capsules of cremains. And under Article 6 of the Outer Space Treaty, Republica is responsible for activities by private entities and private actors, in this case, Mr. Ash. And since harm was foreseeable, given all of the protests, Republica should have instituted stricter mandates against private usage of these capsules of cremains. And finding Republica at fault in this instance would be consistent with the long-standing principle of state responsibility, which stems back to the Roman legal maxim, sic uter tu ad alium non lata, which means use your own property as to not damage another's. In addition to Corfu Channel, in 1941, the International Arbitration Panel and Trail Smelter upheld this principle of state responsibility by finding Canada liable to the United States because a Canadian smelter plant leaked noxious fumes over the United States border.
Was that Canadian smelter plant privately operated or was it owned by the government?
I'm not particularly sure, Your Excellency, but it would not matter in this case because, again, Outer Space Treaty Article 6, Your Excellency, I see I'm out of time. May I briefly conclude?
Just quickly, yeah.
A state is responsible for individual actions, and for all of these reasons, we respectfully request that Your Excellency find Republica liable to Esperantia for damages to Starflight 1.
Thank you.
May it please the Court. Good afternoon, Your Excellencies. I am Krista Laser, co-agent for the Republic of Esperantia, and I will address whether Republica must bear the cost of return of its spacecraft and passengers, whether Republica is liable for damage that Station Ferry's fuel caused to our rare natural habitat, and whether we may prosecute those who caused the death of our nationals. First, Republica must bear the cost of return of its spacecraft and passengers. Article 5 of the Rescue and Return Agreement explicitly requires that the launching state should bear the cost of requested return of space objects. Republica requested return of the Station Ferry and so clearly must bear the cost of that return. Republica requested the return